Our next panel is going to be on compassion and courage in judicial practice. You've already met and heard from our moderator, the Honorable Bernice Donald, the co-chair of the summit. And so without further ado, I'll turn it over to her.
Thank you, Alan, my co-chair. Good afternoon, everyone. Thank you for giving up part of your break. I am from Mississippi, as you heard Judge Carlton Reeves say. And sometimes, even though I'm inside, I forget and I use my outside voice. So if I get too loud, just sort of give me the hand. And if I'm feeling okay, I might tone it down some. But anyway, we're delighted to be with you this afternoon and to talk about this important discussion. Two things I want to say to you. First of all, I want to recite to you a little bit of a poem. It goes something like this. Lost yesterday, someplace between sunrise and sunset, 2 golden hours, each set with 60 diamond-studded minutes. No reward is offered, for they are gone forever. The reason we started a little bit behind this time and we cut your break short is because we realize that the one thing we cannot create more of is time. So with that, I want to introduce our panel after I remind you that earlier today we heard from Judge Carlton Reeves, the chair of the Sentencing Commission, and he reminded us that we're in a system that reduces our empathy, potentially, mercy, compassion, and sometimes it stifles our courage. All of these things are really necessary when we're dealing with the enormous task we have as judges, and you heard Judge Aiken say that minutes ago. We have a panel of judges, and we have seated up here 4 people. I'm going to introduce all 4 of them and tell you why there are 4. First of all, we have Judge Judy Levy. She is a judge on the U.S. District Court for the Eastern District of Michigan, where she served since 2014. Her full bio is in the materials, and you should read about her to learn much more. Then we have Judge Stephen Locher. Judge Locher is a U.S. District Judge for the Southern District of Iowa, and he formerly served as a defense attorney and a prosecutor. Read more about him in the materials. And then we have Judge Esther Salas of the U.S. District Court for the District of New Jersey, where she has served since 2011. And you should also look at her bio and Google her. Maybe it's, okay, I'm so old. Is it Google or what is that other thing where you get video?
YouTube.
Thank you.
YouTube.
Look at her on that medium also. And then we have seated right here, my good friend, the federal defender for the Western District of Tennessee, and she is going to take over when I exit stage right at 3:55. And my apologies, but Delta will not wait on me. We want to start talking about the twin topics here. I believe they're twins because they're necessary in equal measure to do the work that we're called upon to do, and that is compassion and courage. Before I get started, though, I want to thank Olive and the Center for Human Dignity for presenting this powerful conference. This is the 3rd one that Olive and the Center have been involved in, and we appreciate your participation because you make this what it is. And we intend to make sure that we have time to hear from more of your questions. But let me start by asking each of our panelists to give us their initial comments. They'll have 7 minutes to talk about why courage and compassion is important, or any variation of that theme that they choose to. And I want to start first with Judge Levy.
Thank you.
And then with Judge Locher, and after that, Judge Salas. And we'll see where we are at that time. Judge Levy.
Thank you. And just start the music if I go over, and I'll stop right away. So thank you, Judge Donald, and thank you to all of the organizers and contributors to the conference for all of the incredible work. It's been very inspiring to me, and I'm sure to many of you. I want to apologize if I repeat what other people have said since the conference opened yesterday, but what I have learned myself is that I benefit from repetition. So I hope all of you do. It reinforces in me what I want to be able to do so that in the hardest of times, when I'm trying to do that thing, I know that I've heard it before, over and over again, and I'm able to take courage and inspiration from that. So I want to start with the question that people often ask me, which is what is it like to be a judge, and do you like it? And I'm inclined to say I love my job, but I have never answered with that honest answer. I tell them I would like to tell you that I love my job, but I sentence people. I take their liberty away. I change their lives forever. And so I cannot ever tell you that I love it because it's the most painful thing that I do. And so I then move on and I tell people that sentencing is the hardest work a judge does, with no close second. We heard those exact words this morning. And what I want to talk to you about is the 99% of people who are not in a pretrial diversion program, who are not in a Restart or a Rise we have so many different great names, but they are the people who come in through either the front door or, in my case, in the side doors where the lockup is, who have no family, and sometimes a great many family members, but they have no organization advocating for them, helping them, providing services other than pretrial and probation, which I have to say in our district, Tony Marola and Patty Trevino are here. They do just a phenomenal job. But what I want to talk about today is the cases where it's me and the defendant and the prosecutor and the defendant's lawyer. All of our work is hard. And I think that all of it, both civil and criminal, takes compassion and kindness. In terms of sentencing, there is nothing that we do that is easy in that process. We are required, and I believe it's for a good reason, to face the defendant in open court. We can't go into our chambers like we can on a hard civil case sometimes and type up a decision and put it on the docket and go home. This has to be done in open court, facing the defendant. All of the information in the conference today, the hypothetical that Judge Gertner gave us, are tremendously helpful, but at the end of the day, it's me sitting on my yoga mat, it's me walking my dog, it's me talking to a friend, one of my children, a colleague, trying to make this impossibly difficult decision. It requires that we not just know the law, but of course we have to. We have to rule on the objections, grant and deny motions for departures. It requires that we understand the human condition. And the research that was presented to us in this conference helps me understand the human condition better. And that includes what fear and deprivation have done to people, as well as the corrupting influence of wealth, privilege, and greed, and how do we treat those differently. It requires that we understand the purposes of sentencing, which have been repeated here these last 2 days: punishment, deterrence, and rehabilitation. Yet we have to make these decisions understanding possibly none of those will be achieved, that we don't have the resources, and that we have to do what the panel that I was just at and left a little early on what are some creative options that judges and others have used when we know the resources really aren't there. I want to go back to Danielle Surratt at Common Justice and thank Stephen Thomas earlier today for his remarks from Common Justice. I've had an opportunity to meet with Danielle several times and to get to know her. She teaches us that the drivers of violent crime are isolation, fear, and economic stress. And what does prison offer but isolation, fear, and economic stress? Why should we be surprised? But I'm talking to people who already know that. But I heard yesterday one of the judges saying, well, that's a policy issue, and I wouldn't say that at sentencing. I quote Danielle in probably every violent crime sentencing that I do. I talk about fear, violence, and stress. And I tell the prosecutor, I hear your argument, but let me run this by you. And sometimes I see them taking notes and writing it down, sometimes not. It's like, na, boo, boo, there she goes again. But getting back to our topic for today, which is compassion and courage, on the criminal docket we see, I'm fond of telling people, we see some of the people with the worst challenges on their worst behavior, and on the civil docket we see we see them on their best behavior in court. On the civil docket we see people and some of the best people on their worst behavior, but we see them shortly after they've been arrested and removed from their homes, communities, and jobs, and all that they have known. It's the most likely time for an individual to commit suicide within our criminal justice system. And so there's not much more that needs to be said about that. So one of the first things that I do when I try to invoke compassion on the criminal docket is and my court reporter, I think especially likes it, is I speak very slowly during criminal sentencing. I have learned that many of our defendants cannot hear what we're saying. They cannot understand the words we're using. Oh, I have only 2 minutes left. Okay, so I slow down. I use plain English. I don't talk about 3553A factors, departure variance. I break it down into very plain English, and I do that for the doctors who come in to be sentenced, the lawyers, the podiatrists, all of them. The other thing is I explain what I'm doing to the victims, and I address victims. They address me, of course, but often they don't. They sit in the courtroom, and I explain my sentence to the victims because it's often not what they have sent me a letter asking for. It's below what they've asked for, and I don't have access to restorative justice programs to send individuals to, so I want them to know what I'm doing and why I'm doing it. I try to instill hope for the future for defendants. I congratulate every defendant for something I have found in the pre-sentence report. Maybe they got a GED. I say at the change of plea hearing, and I take every plea. I do not allow or permit or ask a magistrate judge to do them. We have so little time to meet the defendant and come to understand them. I watch everything I can. I do not take my eyes off the individual from the minute they show up for a suppression hearing. Fire the lawyer hearing. Fire the lawyer hearing is usually where I get to know people the best, and we have a lot of those.
And Judge Levy, I know that there are other things you want to cover.
I have to
ask you to
stop.
put a pin in it, and I'm going to get you.
Okay,
I promise we're going to let you
I'll
finish
say
that
them
later on.
in answer to a
Right.
question.
So
that,
remember, this is at the fire the lawyer hearing. Okay, we're going to start
Thank
there
you.
again. I want to though give Judge Locher an opportunity to make his comments about courage and compassion, or whatever variation of that theme he chooses to make. Judge Locher.
Sure. So I'm going to start right where Judge Levy ended because she made such an incredibly important point. I'll just read her speech. Structurally, inherently, the way federal sentencing works, it's really easy to find reasons to be negative about the person you're sentencing. You think about the pre-sentence investigation report. For those of you who are familiar with federal sentencing, the first big section is the offense conduct section. And by definition, if you're sentencing someone, it means they've been adjudicated guilty of a federal crime, which means that offense conduct section is going to make them look bad. From there, the pre-sentence investigation report goes into criminal history. Most of the people I sentence have at least some level of criminal history, and it usually makes them look bad. Some people have a lot of criminal history, and it makes them look particularly bad. And not only that, but the irony is if somebody doesn't have any criminal history, it's not like the pre-sentence investigation report then inserts a substitute section that talks about all the positive things they've done in their life. It doesn't happen. It just says none. And then you move on to the next section. So it is really easy to find reasons to be pessimistic about the person you're sentencing. Sometimes you have to look harder to find reasons to be positive. And so when Judge Levy says she finds something to congratulate every defendant for, I think that's so powerful. I try to do the same thing. Every single case, I am very conscientious about finding things to be positive about in that person's background. Maybe it's that they went through 7 or 8 years where they had no criminal history and good employment. Maybe it's that they have powerful letters of support from family members. Sometimes I have to look harder than others. I had a case where somebody had a really long criminal history and was in after probably 10 prior convictions, most for felonies. I had gone through a suppression hearing where law enforcement officers had a poll camera set up on the person's house and showed him doing what he later admitted was indeed selling drugs. On that same poll camera, I noticed that at one point, right after a drug transaction, he went and got his neighbor's trash can and pulled it back in from the street because it was trash day. So when I sentenced him, I made sure to point out that I had seen that, because that told me, it was a little thing, right? But that told me that he cared about his neighborhood, that he cared about the people around him. And I think as a sentencing judge, if you walk into the process being just as open, or maybe even more open, to finding positive things about the people you're sentencing, it leads to more fair and just outcomes. And I'll tell you, the title of our panel is Compassion and Courage in Judicial Practice. When I orient myself to a person in a way that makes me open to the positive qualities they have, the talents, the skills, the potential, all of those things, I don't feel particularly courageous when I impose a below guidelines sentence, because they've already shown me through their own acts and skills and talents and experiences that I can trust them, that I can count on them, that they're worth that chance that I'm supposedly giving them, which again doesn't feel like a chance at all. So for me, when we talk about compassion and courage in judicial practice, those are some of the most important pieces. And another thing it really comes down to is something that I think for this audience is so self-evident and obvious that you almost don't need to say it. And I've been in about half of the sessions so far, and I haven't heard anyone say this explicitly, although everyone is saying it implicitly. That is, you have to recognize the humanity of the person you're sentencing. If you do that, whether it's looking for positive things, finding reasons to congratulate them, communicating directly with them during the sentencing hearing, which is something else that Judge Levy talked about that I try to do too, if you do all of those things, then I think you will find yourself imposing sentences that are more fair, more just, more consistent with the true goals of the system. So those, to me, are the examples of compassion and courage that I try to put forward in my own work.
Thank you, Judge Locher. And now I want to turn to Judge Esther Salas for her opening comments. Judge Salas.
So I echo my colleagues' sentiments, and I want to do just more practical stuff that requires courage and compassion. Everyone in this room has the ability to change the course of a case. Every single person that's been at this conference, whether you're a pretrial officer, whether you're a prosecutor, whether you're a defense attorney, whether you're a magistrate judge or a judge that sets bail, whether you're a district judge and whether you're the United States probation officer assigned the case, you have the ability to change the course and change someone's life. How do you do that? So first of all, Chris Dozier's here. You heard from her yesterday. She is a tremendous resource for everybody. She has research, and we've been all talking about wanting research. Call Chris Dozier. She has research that's going to support a lot of what I'm saying, but a lot of what you've all been hearing these last 2 days. So first thing, and I didn't look at the time, so you got to keep me because I'm a stickler about time. And my husband knows that. So one of the things that, let's be clear, reentry starts at arrest. So in my opinion, the United States magistrate judges and the judges that are dealing with bail determinations make one of the most influential, powerful decisions. Do I let someone out or do I keep someone in? And we have statistics that say if you keep someone in, that person's going to get statistically a longer sentence than the person that gets to stay out, okay? So it's a huge decision, and one that each of you should take back to your districts and talk to your magistrate judges about, or if you're in state court, talk to the judges that are dealing with those bail determinations. The second thing that I want to say is that if somebody gets out on bail, I was here for the morning session, I heard from Brent Cohen, I couldn't agree more, progress isn't linear. We now know, because of books, and I know that Judge Aiken mentioned the book at the panel before, and I thank her for doing that, What Happened to You? We now know that book by Oprah Winfrey and Dr. Bruce Perry, what it tells us about individuals who are dysregulated. If you are talking to a person that has some trigger to do with the criminal justice system, whatever it is, mom was arrested, mom was an addict, mom got sent away, dad never met dad because dad was serving a sentence. When that individual comes before you, he or she is dysregulated. If someone is dysregulated, folks, nothing is getting to the cerebral cortex. Think of dysregulation as a trapdoor that stops and there's no logic or reason that's getting to that individual. So it is our job, each of us in this room, to figure out by an individualized assessment, how do I try to get this person regulated? We all know now that the power differential creates dysregulation. A judge is up here, the defendant is down here. He or she probably is hearing wah, 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 you better behave, wah, 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 I'll send you away, all right? And that is what they're hearing. So how do we begin to get people regulated? That's huge for us to be able to work on. Again, if someone is released and isn't complying, we need to think about how we can bring them in and maybe have a conference with no robe on. Maybe it is to come down, what I do when I have a status conference, remain seated, let's talk, all right? It is about trying to get that person to think differently about you because they don't trust you and they don't trust the system, okay? So it's again, trying to work with them and not yanking them into, taking them off the streets and putting them in jail because they haven't been complying with all bail rules. The third thing that I'm going to talk about right now is district judges and taking pleas. We have this checklist that we're supposed to do, and obviously it's guided by precedent. But we're talking about trying to get that person, trying to get them regulated and doing what we can at a guilty plea to reduce that power differential. So what I try to do now is I change my tone. And Judge Donald, I don't have an inside voice. Never had, never will. So I don't even pretend, right? So I try, though, to lower my tone. I try to make my eyes not bug out so much, but I really do. And then I asked, what high school did you go to? And did you play a sport? And I start talking to them in a normal tone. And then sometimes if you're out on bail, I make you stand for a plea. If you're in jail and in custody, I allow you to sit throughout the whole plea. That's just trying that power differential, right? But the other day I saw a woman that was shaking, right? So you know what? I'm gonna let her sit down, right? So it's when you do those things, you begin to change the narrative in that person's head. So try not to be so robotic, judges that are taking the plea. And then I'm also going to talk later about what we can do in the pre-sentence report process and what we can do in the supervision thereafter. And I am going to say there are some people, folks, that have to go to jail. I'm sorry, there are some, all right? But the problem we are not talking about is we need to talk about why there is no programming in jail so that they can begin to work on the skills that they need when they get out. So instead of cutting the BOP, let's get programs that are actually working and not months and months on a waiting list for somebody. But I do have ideas about the PSR. I do have ideas about my book club that I want to share. I do have a book club with my guys and gals. And just different things that we can do to make a difference because believe me, you can make a difference.
Thank you, Judge Salas. And you actually left time on the table, so I'm going to start with you on this next round because I want to know how does, we heard one of the audience questions before about the pre-sentence report and what's contained therein. And in some districts, I've heard that people who are preparing the pre-sentence report sometimes see themselves as being, having a dotted line between themselves and the prosecutor's office, even though that pre-sentence report is for the benefit of the judge. So I'm going to start with you and ask, how does the pre-sentence report either help, assist, or how does it frustrate your ability to exercise courage and compassion? And after you finish, I'm going to go to Judge Locher, and then I'm going to come to Judge Levy so that she can maybe pick up where she wanted to left off and answer this question.
All right, so one of the things is I do, you got to know your culture and you got to know your atmosphere. The probation office knows that I don't want to see a report that focuses heavily on offense conduct and has a few lines about the personal background. Don't bring that to me because you're going to do a rewrite, right? Another thing I don't want to see is defendant was compliant. Oh, no, 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 no. I want to know, tell me, give me what that person did while they were on release. And when I take a guilty plea, by the way, I've started to incorporate this. If somebody's on bail, I tell them, Mr. So-and-so, all right? Mr. So-and-so, I'm going to let you know you're on bail right now. And that's a privilege, that you're on bail. And I'm going to let you know that everything you do from this moment on is either going to help you and your sentence or it's going to hurt your sentence. And so I'm going to strongly encourage you to, and then I see, whether they've had any issues. I try to identify at the plea whether they are being non-compliant. What can I do to stress to them that this is going to hurt you if you continue to do this? And so what I do, in addition to the probation office knowing that I want the pre-sentence report to give me both sides of the story. And it's got to be both sides of the story. And in my guilty plea, I also say that I need them to cooperate with probation because a lot of defendants and their families don't want to cooperate with probation. They see them as an arm of the law and they don't want to share with them that my mom is struggling with cancer or that I'm actually working 2 jobs and I was selling drugs because I just can't do it anymore, right? So what I do is I tell Mr. Smith, Mr. Smith, I need you to cooperate with probation. And I need you to tell your family to cooperate with probation because that's the report in its final form that I'm going to read before I sentence you. So we want it to be accurate and complete and tell me both sides of the story. So the report in our district, I'm really proud of the PSRs that we are getting out of our district. They're really comprehensive and they tell the story. The other thing I do, folks, is I call the pretrial services officer right before the sentence, and I say, give it to me straight. How was that person? And you want to know, more often than not, pretrial will say, Judge, what a 180. I mean, when I first got him, he was difficult, but he started complying. And I hear all these good things that aren't in the PSR, right? So then what I do is I get on the bench, I tell everybody what I read. I read this memorandum, this one, and the PSR dated, whatever. But by the way, as you all know, I called the pretrial services officer. And guess what the officer had to tell me? So-and-so turned it around. He's got a job. He's doing this. He's doing that. And I put in all the good stuff from my oral interview. Then when I do the oral interview, I turn to the government. You have an objection to me using this oral interview to sentence the defendant to a sufficient but not greater than necessary sentence? What are they going to say, no? If they say no, I'm going to say to my courtroom deputy, call pretrial services officer, I'm going to put them on the stand. I haven't had to do it, but they know I will, right? So then I'm able to use the pretrial services officer's oral recitation to supplement the good stuff, to give me the good stuff, Judge. That's what I do.
Judge Locher.
I don't have a whole lot to add. I try to do some of the same things. I also recognize the PSR for what it is, which is a helpful but not complete story of this person. So I also supplement anything I read in the PSR with letters of support, with my discussion or colloquy with the defendant himself or herself in the courtroom, with other information that I pick up along the way from the record about what kind of person that is and what reasons there are to be optimistic. One thing that I've done, and this is a little bit outside the PSR, but I find it very helpful for me when I approach a sentencing, I want to know what that person believes the best version of himself or herself is, and I want to know what steps they think they can take to try to get there. So when a defendant gives an allocution, and obviously defendants don't have to allocute, and I don't ever put anybody on the spot who doesn't want to speak. I understand how stressful that can be to people having to talk in open court in a sentencing to a judge who, as Judge Salas says, is sitting higher than they are. But if they're interested and willing to speak, then I always ask them, I'll find something in their background. And I'll say, look, you had this 5 or 6 year period where you weren't getting in any trouble at all, and you had a good job, and you were a parent to your child. What allowed you to be in that position, to be successful for that 5 or 6 year period, and how do we get you back there? And I am in a relatively small district. We only have 3 Article III judges. We see the same attorneys over and over again in our cases on both the prosecution and defense sides. The defense attorneys have already started picking up on this. And now a lot of times when I get allocutions from defendants in criminal sentencings or revocation hearings, they'll come in and they'll say, here's what I'm going to do. Here's my 3-step plan. Here's the job I want to get. My uncle's got an electrical company, and I started the training, and I know I can finish it. They've already got that plan that they're starting to put together, and that helps me so much in terms of visualizing what they're going to be and how productive they're going to be. That kind of information I use to supplement some of the shortcomings in the PSR in terms of telling the whole story of a person's background.
Judge Levy?
I'm so glad I'm attending this conference because I just wrote down what Judge Locher said, and I'm going to start asking that question of defendants is what is the best version of themselves and how are they going to get there? And then I'll try to help them get there, so thank you for that. Our district does something phenomenal, which is that pretrial always sends us a memo the morning of sentencing or maybe the late afternoon before with an update that's up to that moment of what has happened since the pre-sentence report was written and the date of sentencing, which can be 2 months, 3 months, 6 months, a year, depending on cooperation or whatever else is going on. So I take that into heavy consideration for all of the reasons that Judge Salas mentioned. Another thing that I do is during the pandemic, for some reason, our court started a thing where we didn't allow people to stand to address the court. I don't know why you would get COVID standing and not sitting, but maybe it was, I know why. I know why, because we used to have the plexiglass, and then we learned that makes it worse. But once I realized how much more time I could spend focused on the defendant and the process and less with an up and down. I just said, forget it. I don't want anyone standing, civil or criminal. Stand to make your appearance and introduce yourself. Then let's be seated and let's just work together. Now we are working together. And I also talk about our work today is the following. We are going to do the following together, and I use those words. Another thing is picking up on what Judge Salas was saying. I make sure in every sentencing hearing where it does not involve victimization of children or child pornography or things of that nature, I talk about love. And I make sure I use the word love. I find somewhere to put it in. Unconditional love that you deserved was not there, based on what I've learned in the pre-sentence report. And I'm sorry, and I apologize to the defendant that those conditions were what they were. Another thing I wanted to talk about is, I might be overly focused, but the AUSAs, we're a large district, not a extra large, I think, but we're a large district, a couple hundred AUSAs. So I have a different situation of different people coming in, but some repeats. And they make these arguments, which we heard from the panel this morning, we heard from Judge Gertner, that, Your Honor, Wayne County, which is the Detroit County, those judges are soft on crime. And this defendant has 3 or 4 or 5 felony convictions, and look, only 1 year or 2 years or 3 years. Now it's time for more. And so I address them directly every single time that argument is made, which is in about 85% of the cases. that it's the prison industry is the only one, which we heard this morning, that we reward when they fail. If it didn't work last time or the last 4 or 5, 6 times, why is it going to work this time? And so then I say what I want to do is fashion a remedy that will work. And then I'm talking about CBT and substance abuse and parenting classes and all those sorts of things. But the other thing is there feels to me in the courtroom that there is a headwind against the judge going, I'm significantly below the guidelines in virtually every case. And it feels like a headwind coming at me, trying to come up with a new argument to go higher. And so I have responded, and then I'll be quiet, but I have said repeatedly on the record that I want you to understand that the guidelines are astronomically high and they have had a corrupting influence on the process. And so I tell them, this is what, if I go into a store because I want to buy a lamp, it's $1,000 and it's on sale for $600, I think that's a great deal. Well, it turns out the lamp is worth 25 cents. It doesn't work, or it's not worth anything. But I've convinced myself, and we've all convinced ourselves, and I'm telling the AUSAs this, I talk about a Rolex. I mean, I give a different item that I'm shopping for every time so it doesn't get too boring for me. But there is a corrupting influence that, so I look at what other countries, I look at what Sweden and Norway and the Netherlands, I look at what other places do in the face of violent crime and drug crimes, and I try to learn from them and import that into my own practice.
Can I
Yes,
just add on
please.
something? One of the things, though, I hear you, Judge Levy, but one of the things that I think we need to do is we need to recognize the environment we're in, and we need to have evidence-based research and status that's going to support our decisions. But defense counsel and prosecutors and pretrial services, we can justify our sentences, we can justify our variances, but that has to be, and this is what I say to the defendant who comes and says, who pleads before me, everything you do at this moment forward, is going to have an impact on your sentence, right? Because I want to justify it. I want to make my sentence, and I hate using metaphors for those of you who know our story for obvious reasons, but bulletproof, right? And that requires defense attorneys to take an active role in their client's case, right? Which means that if you've got a guy on LM, we talked a lot about LM, but in my opinion, if it's jail or LM, listen, let's take LM, right? But then it's incumbent upon the defense attorney to begin to talk to his client about, do you want us to step you down? Well, if you want to step down, we need you to start going to, you need to get sober. We need you to, I heard you took an HVAC course. Go back, right? Start doing things so that I can go before the judge and say, fully compliant for the last 30, 60 days, here's what he's doing, let's put him on a curfew. And then when he does well on the curfew, let's step him down off electronic LM, right? It takes defense attorneys to get proactive with their clients. And again, give us what we need so that we can make a variance that is bulletproof, that everyone can see the justification, and we make sure that the record is sound. And some, by the way, I don't know about other district judges, and my chief's not here, so if you tell her I said this, I'm going to deny it. I don't care about my docket and it's being aged. I put off a case for 2 years so that the defendant could prove to me that he had changed. He got married, he got a job as a chef, he was involved in his church, he was, his wife, they had a family now. I'm not putting that man in jail. But for 2 years, he built the record for me. And that defense attorney worked with him to build the record for me. That is what we have to do. We have to be proactive. That's why when I started, I said, Every single one of us in this room can make a difference. And if you're working with nonprofit corporations or companies, then, you know, maybe we start working together to give resources to non-addicts, because we were all talking, if you're an addict, you got tons of help in the federal system. If you're not an addict, there isn't a whole hell of a lot that you can get. And now we're finding out about second chance money and how second chance money at the pre-trial phase can be used to help your client get a CDL, can be used to help your client learn a trade. And so let's start thinking about different things that we can do with that second chance money. So I agree with you, Judge Levy, that we, you know, and you've made a practice of starting. I'm a little more conservative. Mm-hmm. I am. You know, I don't know, but I'm not afraid to exercise my discretion, but I need people to build the case and give me the facts necessary to make my decision sound and consistent across the board.
Thank you. This is probably going to be my last question to you, but one of the people in the audience, might have been this gentleman on the front the other day, mentioned that there were a lot of black and brown people, you know, left in the system, and he's been working to help some of those people gain their release, not just black and brown, but people who shouldn't be there. There's a lot of skepticism among groups about the fairness of the justice system. And I will say to you that each of us, whoever we are, wherever we are, we view life and issues and facts through the lens of our lived and learned experiences. That does not mean that Judge Salas is going to view things through an Hispanic or Latinx lens because she was the first Hispanic woman to be a U.S. magistrate judge or a district court judge in New Jersey. But it does mean that all of us have an accumulation. We built a database in our brains for things that we've observed, experienced, learned, and some of them are facts and some of them are perhaps alternate facts, but they're there. And they help to color the lens. So I want to ask each of you, starting with Judge Levy, what do you do in your courtroom to make sure that every person standing before you is seen and heard? How do you give them a sense that their case is the one you're focused on and that you're going to be fair and just to every person who comes before your courtroom, and that the other participants in that courtroom are going to do their part to create an environment that is fair and just? Okay, and then just take that any way you want to take it.
Okay, I'm going to try not to talk too long. One of the things that I do is I make sure that everybody who works with me at the court, from the CSOs, the deputy marshals, that can be challenging, but certainly all of my staff, but the court security officers, we're copacetic, we see eye to eye, that from the minute somebody shows up, they're treated properly. If you don't have to look in it, if you're gonna look for an ID, then look for everyone's ID. If you're not gonna look, then don't for anyone. So everyone reflects, I have, when I hire law clerks, they reflect me, and so everything they say, I tell them when I offer them the job or when I'm interviewing them, that we're all going to make mistakes. Sixth Circuit will correct a lot of mine. They won't see some of them. But the one mistake we cannot correct is being unkind to somebody who comes in this courtroom, because you can't fix that in the way you can fix other things. So I make sure that there is kindness and civility and just normalcy to everyone. I try to have my staff reflect the community that we're serving. So I make special efforts to exercise my hiring discretion to have my law clerks, case manager, court reporter reflect the community. I also have an affirmative action hiring program for interns, and I hire almost exclusively previously convicted interns and people returning from recovery. Twice I've gotten phone calls, urgent, from the chief judge in the middle of the summer. Judge Levy, or Judy, they call me. We just got a report, the background check. Your intern has a felony firearm. That's why I hired him. That's why I selected him. Thank you for sharing that you know that. So now they know that that's why I'm selecting these individuals. But then they talk to me. During the pandemic, I had one of my interns on the Zoom call, I make sure that they can be seen. And afterwards, he said that was one of my many defense lawyers when I was in and out as an addicted to heroin. And he told me what it was like to have this individual as his lawyer. It gave me more insight. So those are a couple of the things.
Judge Salas?
One of the things I try to do, I'll just give you two, is that when I'm talking to a defendant, I'm really looking at the defendant. How many judges during certain hearings are doing this, or doing that? You gotta look at the people that are in front of you and really try to connect with that person. And I happen to try to see if there's something, being so observant, I can see the other day, I saw a defendant that when I asked, did your defense attorney go over the discovery with you? She was like mad. And I had to take a break, and ultimately her facial gestures told me that relationship was not working, and I've given her new counsel. But, so really look and be observant. Words matter. I read a book that has, I actually have a book club with a lot of our individuals under supervision. We read What Happened to You in My Recovery Court, and these folks loved the book, and we did a chapter a month with our recovery folks. But I read a book called The Four Agreements by Don Miguel Ruiz, and the agreements, the first one is be impeccable with your word. And so I have this whole thing in front of my bench that says be impeccable. So what I try to do is never refer to a defendant by a defendant. I say his name, her name. We no longer use we would no longer use the word defendant or offender for supervision issues, all right? They are individuals under supervision, and that's how we refer to them. Individuals under supervision. Words matter. How you make people feel, that matters. And so those are two of the things that I do to try to connect with the individuals that come before me. And I was very moved by Mr. Poulis's opening remarks when he talked about everything everyone told him he couldn't do. Yes. Oh my gosh, that was so powerful. And so I try to tell somebody, I care about you. If they come and they say, I don't want to put you back in, don't make me do that. And so I think when they sort of see me like begging them to try to tell us what you need. But now I think because of this program, I really am going to try to incorporate all the things that they can do as opposed to what they can't do. So I just wanted to thank Mr. Poulis for that.
Judge Locher, and when you finish speaking, I'm going to exit.
Sounds good. Just one thing to add. When I start a sentencing hearing, I try to get the defendant talking right away. So I tell them what the purpose of the sentencing hearing is. I tell them in at least general terms how it's going to go, and I ask if they understand. And I make them answer verbally. And then I tell them, if I say anything today that you don't understand, or if something happens that you're not able to follow, I want you to interrupt the proceeding and tell me. I'm giving you permission to do that. I also tell them, if you reach a point where something's confusing or you want to talk privately with your attorney, I'm going to give you the opportunity to do that. You're never going to be in trouble for that. You're not delaying my time. You're not inconveniencing any of us. It's that important to me that you understand what's happening. And I make them give verbal answers to each of those things, and I do that very deliberately. I want to make sure from the very beginning they feel like an active participant in the process as opposed to just a passive observer. And as I go through the hearings, my sentencing hearings take longer than my colleagues do on balance because we do have a lot of times where the person I'm sentencing will want to stop and talk to their attorney for a minute. But I really like that because it tells me that they are taking an active role. And as we've talked about for the last 2 days, with the exception of victims, there's nobody who's affected more by a sentencing decision than that particular person being sentenced. And if it happens in a way that they feel like they didn't even have a role to play in the process, that they were just listening to other people make these hugely consequential decisions about their lives, that's a real problem. So for me, in addition to the great ideas that Judge Salas and Judge Levy have talked about, which I agree with, I also just try to get them talking in an active way so that they feel like an active participant.
Thank you. At this time, Federal Defender Doris Holt is going to take over, and I believe she's going to start the audience questions, but she's going to stop those in time to give each of our panelists 2 minutes to close.
Thank you, Judge. And I know this is a little early, but you judges have been phenomenal. And I know the audience, we want to take them back to our districts, don't we? Okay, let's, do we have someone with microphones that, I see a couple of hands up. Stand so that they can see that you're the person that
Right
wants
there,
to
right
ask
there
a
in the
question.
red.
Red.
Yes, I
Okay.
love it.
Now, and
Okay.
would you tell us who you are?
Yes.
And tell us who you want to address your question to.
Okay, yes. My name is Sarah Martin. I'm a commercial banker for TC Federal Bank in Savannah, Georgia. I'm here with Justice for Jessica Linton. One of the consistencies I've kind of heard from everything from the last couple days is about cost is an issue, and then also one thing I've heard throughout this panel discussion, which was very interesting, is the attorneys. I feel like there's a big disconnect between the attorneys and their clients and what they're actually doing to help. And some attorneys will say, oh, I'm a criminal defense attorney. I can do this, that, and the third. Well, but really they're really doing trafficking court and they're going through DUIs and divorce court and all this stuff. And so my question to y'all is, how would we be able to decipher the best attorney for a certain situation, a white collar crime in particular?
Well, let me say that it's tough for judges to be able to. We don't get involved, at least at the federal level. We don't get involved in plea negotiations. We're not allowed. All right. So the first time I'm seeing someone is an arraignment. I'm seeing someone at a status conference, which we now hold just to confirm all discovery's been exchanged and whether I can expect to see motions, and then plea and sentencing. So ultimately, it is tough, but to do, in my opinion, I was a federal public defender, so full disclosure, love the federal PDs. They're 9.5 years. In my opinion, there is, federal PDs are the best attorneys money can't buy. And so, they work in the district, they know the judges, and unfortunately, a lot of times people didn't have faith in us, and they would go and hire some private attorney who didn't know anything about the district and made some, I think, I could point to a couple cases, some bad decisions. But so you got to do your research. If you're not going to stay with the federal public defenders, then know who you're going to. Contact your association of criminal defense lawyers. Call the bar. Know the names. Everybody in their districts know the good attorneys and the reasonable ones too, because there are some attorneys that are just, their fees are so cost prohibitive. So it's about research and homework, and at the end of the day, I am going to say this. It's a little bit about intuition. When you call your attorney and that attorney isn't calling you back, or that attorney is just giving you, yeah, I'll deal with that later, trust your instincts and your intuition. If they're not connecting with you, they don't have the time to return a call, there's a problem. So I'm a big person on intuition. Any of my colleagues want to also talk about that?
Before they do, let me just ask the other two judges.
I can hear it.
Am I good? Let me just ask you all. If a white-collar case was in your courtroom, would you first appoint the Federal Public Defender's Office if the person says, I cannot afford to hire a lawyer? Would you do that first?
Absolutely.
What about you, Judge Locher?
Same.
Okay. And do you ever tell the people, so now if you can afford to hire your lawyer, you can always hire your own attorney?
Yeah.
And a lot of times, as a federal public defender, I would tell, when I was in the courtroom every day, would tell the clients, look, let me work on your case. If your family get the money together, they can always hire you a lawyer if you don't want to keep me. But most of the time,
They want to keep you.
they would say, I think I want you to stay on my case. So at least let them work on the case if they're appointed a federal public defender and see. Anyway,
So
are there any other questions?
I'm glad someone finally brought up white collar, because for 2 days, that's the first time someone has brought up white collar offenders. So my question is, not only why there's nothing that seems to be an alternative to incarceration for one of the populations that is least likely to reoffend, but also, what do you do about the trial penalty for those of us who do choose to exercise our rights, go to trial, and then we're looking at a longer sentence because we dared to use our constitutional right?
Colleagues?
Well, the trial penalty is built into the guidelines. So if the guidelines are advisory and you're aware that there's a trial penalty, which I think everyone in this room would be aware, there does not have to be a trial penalty. But I'll tell you, my philosophy on many white-collar crimes is that this is a different offender population. It's a population that has had, generally speaking, every access in the world way above my own access to education and other things, and has made certain choices that may be different from people who are in running a drug trafficking organization or involved in one or involved in violent crime and things of that nature. And there I have a hope and a prayer for deterrence. I had a doctor who, when the search warrant, he was running a pill mill, and when the search warrant was executed, he had cut and pasted onto the wall, next to his computer, some articles about of other doctors getting arrested for running pill mills and for doing engaging in white-collar crime. So I feel some hope that a sentence would deter others in the fraud department, Medicare fraud, Medicaid fraud, pandemic unemployment, PPE loans. There's an epidemic of fraud in the Eastern District of Michigan, healthcare fraud. Certainly we are inhumane in the length of some of these sentences, what the guidelines might recommend, but it's my own personal philosophy, and correct me, everyone, if I'm wrong, that's one area where deterrence might actually be served by reports on sentences.
Judge Lochner?
So
Locher.
I did a lot of white-collar work, both as a prosecutor and as a defense attorney, and there's probably a lot more variation among defendants in white-collar cases than there is in the average drug or gun case, meaning, as Judge Levy just alluded to, a lot of times white-collar offenders come from much more privileged backgrounds and have much more opportunity. Now, not always. I've had white-collar cases involving small business owners who sort of worked their way up from the ground with no real advantages, and then when things got tough, instead of doing what, in retrospect, they obviously should have done, they lied to the bank for a little while. And they got caught, or maybe they didn't get caught right away, and then they kept lying more, and the next thing you know, it turns into a $2 million fraud, but you look at it and all they ever really did was just keep their business afloat and pay their employees. So white-collar cases are hard for me to make any specific comment on because there's so much variation. There are certainly times, and I had these cases as a defense attorney, where the guidelines would run up so fast, all based on the same conduct under the guidelines. So you've got more than $1 million from a financial institution, and you get +2 for that, and then the sophisticated means enhancement, and you get +2 for that, and they used the means of identification of another, and you got +2 for that, and the next thing you know, you have a 46-year-old first-time offender, no prior criminal history, with a family who's facing a 292 to 365 month guidelines range. There are certainly places where the guidelines can run away in white-collar cases, just as there are in other types of cases. But it is hard to overgeneralize, or the potential exists to overgeneralize when it comes to white-collar cases because there is so much variation.
I will say, though, we have to continue to think about every case is an individualized assessment, and we do have to do, and I think that district judges now, at least federally, take that seriously, and we sort of look to information in the PSR about, whether this individual was continuing to behave in a pattern and practice. This was their second offense, right? Depending. So I think it's very difficult for us to talk about it, but one thing's for sure, right now, and somebody quoted, I think it was Janet Reno, who said we can't build our way out of these problems, and so we're going to have to, and I took that from the last panel that I watched, so thank you very much to Judge Ginger Lerner Wren. But the thing that I am going to say is that we have to start looking at alternatives, and it has to be applied. I apply what I've learned in my alternative court. I run a pretrial opportunity program, a front-end program, and I've been taking everything that I've learned and apply it now to my general population. And so by doing that, I am trying to sort of now incorporate the knowledge and everything that I've learned from the Center of Law, Brain, and Behavior and other programs that have taught us about neuroscience, that have taught us about the things that we need to focus on, and maybe perhaps in those appropriate cases, varying when we can to adjust for a first-time offender. In New Jersey, we have now, it's actual loss, not intended loss, which has helped with the guidelines a bit when we're talking about white-collar crimes. So, I'm just, one of the things I do want to say before we take another question is that we are perpetuating a circle of individuals that sort of, it's an endless circle of family members that are going to jail. And one of the things that I think we need to do is think about trauma on families and what we can do to alleviate some of that trauma to that young child. There's a lot in What Happened to You. There's so much there. I strongly urge everyone to get that book. But one of the things that I've tried to do is if I got a mother and father in a case, I staggered the sentences. The U.S. attorneys weren't really happy about that, but the father, who is a citizen, is going to serve the 6-year sentence. And they ran a Ponzi scheme on most of their family members and depleted them of their life savings. So they had to go, and their behavior indicated that they were not receptive to rehabilitation, from my perspective. So dad is doing 6 years, and mom, who's not legal, will stay with the baby until dad is able to come out, and mom will then go serve her 6 years. So there are so many creative things that we can do, but we have to be mindful that there is not one size fits all. And I think that's one of the things that I think we're all trying to say is there are individualized assessments that need to be made very carefully, and we need to think about alternatives to those ultimate incarcerative sentences.
I agree. Don't you all agree? Yes, yes, yes. And Judge Salas, we can take that money. We can take the money that they made in these different schemes and just give it back to the people that were injured.
Yeah. It's tough.
Yes.
It's tough.
Next question.
Yes, hi. I am a lawyer and work a great deal filing compassionate release motions. And I find that a lot of judges are not very compassionate and not very courageous. And so since you are, what can I do as a litigant to encourage judges to break the mold, to be the first one to grant compassionate release to a mother that needs to get home to her child because the caretaker is dying? So yes, help me help them.
I wonder whether the data that has been provided, the type of data that we've gotten at this conference would help in that situation. That I tend to grant those motions, so I can't speak. But I made a formula. I made my own formula during the pandemic. If you had a high risk factor under the CDC as it evolved, and the vaccine had not yet been made available to you, and you did not have a serious discipline record in prison or could explain to me what had happened, you're out. And then it wasn't that hard. But I don't know what to offer.
Just keep filing them? Just
No,
keep
there's
filing the
gotta, but I
motions?
think data is going to be key to telling the judges also that the Sentencing Commission is changing the standard and encouraging judges to live up to that.
You know, I would say continue doing what you're doing. Don't give up. Try to really put the best foot forward when you're submitting these motions. You know, really painting the picture for the judge, knowing what the standard is, addressing the standard head on. In a closer call, say why this is the person we can take a chance on. You know, sometimes I don't see there being enough of that advocacy and really, in my opinion, making the point that needs to be made head on. This is a close call. We recognize that, but let us tell you why. And so you know, I've granted them, and I think that at the end of the day, we all make the best call that we possibly can. And I'd like to believe that we're all compassionate. I'd like to believe that a lot of times, though, this information isn't getting to our colleagues that need to know. I think the people on this panel are probably more receptive, but across this great nation, these kind of phenomenal programs aren't getting in front of the judges that need it. And so that is why I believe that we need to start addressing training for new judges. Baby judge school is what we call it, right? It really is called baby judge school. That's what we call it. But we need to start having baby judge school talk to us a little bit more about, instead of, I'll tell you what I heard when I went to baby judge school. We were sitting around, I'll never forget it, and they said, you better watch the guidelines, because if you guys don't do the guidelines, they're gonna have mandatory minimums on every crime. Remember? I mean, that's what I heard, and I'm a brand new DJ, and I'm going, okay, so I don't want to be responsible for mandatory minimums all across this country. They'll say Esther did it, and I'm like. So there's like that kind of thought that you're new and you want to do a good job. All of us, listen, we don't take this job. At least I can say for most of my colleagues and the colleagues that I've had the good fortune to meet across this country, we don't take this job so that we can make everyone else miserable. We come to the bench. Some of us leave, not me because I was federal PD, but some of us leave very lucrative jobs to come here, And we really do try to do the best job, but we have to be informed of the research, Chris, the research that says that what we've been doing, the definition of insanity is doing the same thing over and over and over again and expecting a different result. We have to show our colleagues that there's statistics and data that shows that we can go ahead and use some of these alternatives to fashion sufficient but not greater than necessary sentences. But we in this room have to take back to our districts this good information that we heard, and we have to encourage all of the agencies and all of the judges to start looking at trauma, start looking at adverse childhood experiences, start looking at the data, start talking about the real problem again, which is we're not helping the people in jail that have to be there at times. And that is a huge frustration of mine, because we sentence people to these incredibly long sentences, sometimes without a choice if it's a mandatory minimum. They go in and then they get nothing. I had a defendant literally say to me, I could see it was Zoom, and he was pissed, right? And he's like, And finally, the old Esther, I always define my life, and I don't want to, but I always define my life as, sort of a changing point that happened in 2020 for me. But, the old me would have been like, why are you making faces? What's your problem? Right? The new Esther was like, sir, do you want to be heard? You bet I want to be heard, Judge Salas. You told me I was going to get help in jail. You told me you ordered all these programs, Judge Salas. Do you know how many programs I got? And there was this silence. He goes, nothing, Judge Salas. And now I'm before you on a violation here, and you expect me to be a changed man? I'm not a changed man, and I'm getting mad and angry. And I was like, I heard him, I let him go. And then I did, I let him out. I let him out, and I let him start working with his attorney to try to get him the help he needed. Now, it took a chance because he wasn't behaving the way he was supposed to under supervision, but the man got no help. And we talked a lot about soft skills. For some of these people, they don't know the soft skills, like getting up on time, which I loved hearing from Mr. Tavares about that. So, we've got to start doing something. If we're going to send folks to jail, we better start investing in trying to help with CBT and other known treatments that will help them when they get out. Just say.
Is there one more question?
Yes.
Okay.
Carlos Williams, federal defender, Mobile, Alabama. I want to talk about the new pariah in federal criminal cases, meaning child porn, the sex cases. I know that these are not the cases that people usually want to talk about, but it's some of the most difficult cases that we have. I know that when I had my very first, it wasn't my first one, but one where somebody had no record, impeccable, former Marine.
Talk into the mic, sir.
Former Marine. He was captain of a tugboat when he was arrested. And when he was arrested, it was almost a relief for him. He confessed completely to all the child porn he had, gave them this 20-something number password, which they would never have cracked, and had a ton of porn on it. And he had one contact offense. During that case, I learned a lot about people like him who, around the age of 13 or 14, realize that their taste in who they're attracted to does not change. And I learned through literature and research and everything else that 2% of the population go through this, meaning when they're children, when they're still children, their taste does not change. I don't know how many of you know anything about this, but clearly our law does not reflect at all the kind of experiences that they go through. They don't really reflect the studies. And when you have a case like that, there's no place to go but up. It's all very high sentences, life sentences. Everything is an upward departure. And of course, Congress took much more independent action on this than even the Sentencing Commission. There's no study done or anything like that. So my question to you is, how do you see these cases, and what do you think may be possible or coming down the pike, so to speak? Thank you.
Judge Levy?
I'm really glad you brought up those cases because I had them in the back of my mind with white-collar cases to talk about. And I think, first of all, I would strongly encourage you and everyone here to address the Sentencing Commission because almost all of those cases have mandatory minimums. 5 years for just possession of child pornography goes to 10, 15, 25 for a child exploitation enterprise. And so I think the first thing is to understand when I was appointed, I went around and met with all the judges on our bench. One judge, Judge Cohn, recently died at 97, had a table full of stacks of things. And I said, oh my God, what is all that? You know, do I have to read all that? He said, that's all on child pornography. And he wanted to understand what you want to understand is what has happened to these people and what is the right sentence for them. And I have tried to do my own reading and understanding, and so far as I can tell, it is a mental, emotional, developmental problem. Especially for those who have possession and trade and all of that in this horrible stuff. And I also call it child exploitation images and not child pornography. I don't think it should be normalized. And so many Americans and others have access legally to pornography, and that's not what this is. It's an exploitation image. But so I would suggest addressing the Sentencing Commission, but also presenting the research to the judge about the fact of what this individual's mental health issues are. I tend to sentence at the mandatory minimum. I don't know that I've ever had a case that didn't have a mandatory minimum. And when something especially egregious, if there are images, or if there's actually touching or images of babies that are being exploited, it's harmed, to send a message, I'll go 6 months higher. But it's already so long, and what I've come to understand is that the BOP programs to treat sex offenders don't happen until the end of their lengthy sentence. So they may be effective programs, I don't know, but if they don't happen till the last 2 years, you're just reinforcing the same thing all this time. So I don't have a lot to offer.
Judge Salas, do you have anything, Judge Salas, do you have anything to ask?
You know what, I heard Judge Reeves say, you know, if there's a concern, write the Sentencing Commission, and I think people ought to write the Sentencing Commission when they feel so strongly about something and talking about, you know, these very difficult decisions, and they're very difficult decisions that we make, but more often than not, we're guided by mandatory minimums in those cases. And we try to do what we can. I have an individual under supervision right now, and I have him reading What Happened to You. And our first status conference, because I hold status conference for high risk and high need offenders, not everybody, but status conferences when they get out of jail. 30 days after they get out, they come and see me. And we had a status conference with him because he wasn't my original case, and he started going to parks again, and he was seen around children, and so there was a concern. And I brought him in, and I have him reading What Happened to You, and we had a great first status conference because the book was enlightening, and it was a very powerful moment on the record with him. So the only thing I can say is that we've got to try to treat when appropriate, you know, when we can. And when can we do that? When the individual is under supervision, and maybe try to be compassionate. And that's what I tried to be with him. And so far, so good. He's complying. But these are really tough cases because of children being exploited and the danger that involves some of these cases. But with that, I know we ran out of time.
But I want to give a final word to Judge Locher if you want to say something in relation to the child pornography case or child exploitation cases.
So for whatever reason, in the time that I've been on the bench, I've had almost none of those cases. I'm interested in the research that the person who asked the question described, and beyond that, this is probably an issue where I need to do more listening than talking.
Thank you. Thank you all very much.